Divorce TV with Wally Marcus. My guest today, Divorce and Alimony with attorney Keith Singer. Support for Divorce TV provided in part by the Center for Divorce Mediation, 520-577-1202. Hi.
Hello.
This is Wally Marcus, and I'm your host for Divorce TV. We've been off for a little while because some of the budgetary problems that Access has had, and we're really happy and proud to be back. I've been a divorce mediator for over 26 years, and our topic today is divorce and alimony, and I'm pleased to have attorney Keith Singer, who specializes in divorce and also does divorce mediation and does lots of other divorce as well. So he's a very knowledgeable guest, and we're going to be talking about alimony. You can get more information about our program and our guests, our contact with questions at our website, which you'll see periodically at the bottom of your screen. So we'll do that. Keith, can you tell us a little bit about yourself?
Sure. I'm, as you said, a family law attorney here in Tucson. I've been practicing about 13 years, almost exclusively in the area of family law, although I've also practiced in juvenile law and some other trial-related areas. But family law is really my life, my life's work, and I believe in it and all the ways that it can help people and families. And I'm happy to be here and honored to be able to speak on the subject.
Keith, we talked about some of the questions in advance, but every time we do the show, I find that something pops into my head, and the way you were talking is, why did you choose family law?
I grew up in youth and family work, and so it wasn't a unnatural transition to go from that sort of work with families and children to law dealing with families and children. So to me, my prior life in that field has been a really useful transition to family law work. But family law is an amazing area. It calls upon so many sub-areas of law, and it brings so many aspects of people's lives and the legal profession together with the ultimate goal of helping people, helping families, and really getting people on with their lives and outcomes that are good for children, good for the parties, and good for the community. And I am happy to and really thankful to be able to practice in this area of law.
That's good. Before I forget, I want to switch the screens here so that we can get you. If you want more information about Keith, this is his telephone number and his website. We'll do this a few times during the show, so if you don't have your pencil and pen out now, you can get. We'll do it later on. Keith, our topic today is alimony or spousal maintenance. It has to be both. As a matter of fact, I think we were kidding around before the show, and I think one of the things that was funny, I saw on the shelf of the recent store Alimony Ale, and you talked about irreconcilable differences. So I think it's cute. It's in our culture, but a lot of people don't understand. What is spousal maintenance?
Spousal maintenance, I think, is a newfangled term, so to speak, for alimony. The terms are interchangeable, and it's a way for the court process to help spouses who are in need of financial support at the end of a marriage to get back on their feet financially and to maintain a level of financial stability into the future.
Good. Who's eligible to receive spousal maintenance?
To start, married couples or divorcing couples are eligible. In other words, never married couples, paternity cases we would call them, are not eligible for spousal maintenance. You've got to be married in order to make a claim for spousal maintenance. And beyond that, spousal maintenance is a possibility for a divorcing couple. So anyone really who is involved in a divorce is eligible for spousal maintenance if they meet certain other criteria. But at the outset, any divorcing couple can consider this option.
It's interesting. I guess once again, the questions that sort of pop in my head as I long. I don't think Arizona still hasn't legalized same-sex marriage, if I'm correct.
No,
but if there were, there would be potentially alimony in that kind of a case as well.
Absolutely.
Okay. Who's eligible, which sort of segues into who is eligible to receive alimony?
anyone who is divorcing is potentially eligible to receive spousal maintenance.
I mean, what I'm really gaining at is that I think alimony tends to be perceived as something that men pay and women receive. But really, I guess the question is can men receive alimony?
From a technical legal perspective, men can receive alimony and women can receive alimony. And more in our society, the female in the divorce is making as much and often more than the man. So I see more and more spousal maintenance cases where men are the recipients and women are the ones paying the support. But as a practical matter, it's still the case that women receive more of spousal maintenance orders, I think, than men do. There may be some perception still in the legal process from all levels that looks disfavorably, frankly, on men who are seeking maintenance. But it's not impossible. I think it's harder.
Sometimes, and I've seen cases at that point where sometimes they don't get alimony, but they get something else. Is that... I mean, I had a case once where the wife was making $1 million a year. The guy was unemployed for 2 or 3 years, and she just gave him, more property settlement.
Judges, I think, believe, and from their own perspectives, they are equal in the way they treat men and women. And there's a lot of feelings, I think, in society that men and women are treated differently in the divorce process. My clinical experience is that the divorces I experience, the judges that I encounter truly treat men and women equally. But having said that, there is a little bit of a bias against men who seek spousal maintenance. So if the man is going to seek maintenance, sometimes courts or the lawyers will look for another option other than to take that approach. But if there is a large disparity of income such that the wife is making a lot more money and husband really is in financial need, modern courts won't hesitate to consider spousal maintenance for men.
I'm a little bit older than you are, so that no fault came in just when I started practicing nationwide, and the judges were old line and didn't see it as much. But I think they are changing. I know it's changing a lot. But what about when in a men and women situation? Do you find that there's a different standard? I want to talk a little bit about standards. Maybe we should talk about standards first, and then go. Are they applied differently to men or women? But how do you figure out what it is? How much alimony? How do you know?
Well, technically, the standards apply equally to any party that comes before the court, and I don't want to give the impression that any of the judges will treat men and women differently under the law.
Not just necessarily men and women, but I mean, are there guidelines? Are there ways?
Yes.
Once again, I'm sure you get the question I get all the time also is, what are my rights? What am I entitled to? What's the court going to do here?
There are statutes in Arizona that address the way in which spousal maintenance is calculated and considered by the courts. In general, the way the statute works is first the parties will submit financial affidavits to the courts, financial affidavits that will indicate their income and their expenses. And then the court will look into the facts beyond just the current financial situation. First, an evaluation is made as to whether one of the parties to the divorce is eligible for spousal maintenance. The court will look to factors like their incomes, what property...
Let's go back to the eligibility.
Sure.
What makes them eligible or not?
Range of factors.
Okay.
I think primarily courts look to the financial factors. Does someone need spousal maintenance? And if they don't need it, then there's no entitlement for it just because they are holding a grudge or because they feel like they've been done wrong or for a reason beyond actual need.
What are the needs then? I mean, at that point, are the needs... I need a new fur coat, or I need a new car, or I need, something else. Need is sometimes in the eyes of the beholder, I guess.
Need based on real necessary expenses that the party who wishes to receive spousal maintenance is experiencing in their lives. Basic things like what is their housing expense, what is their insurance expense, their food expense, their transportation expense, things that are required for day-to-day living. These are the sorts of things that courts are going to key in on in determining whether there's a financial need.
Guidelines? I know Maricopa had guidelines and it no longer uses the guidelines, if I understand it correctly, but are there guidelines?
There are no guidelines.
I mean, because with child support, clearly we have guidelines.
When we speak of guidelines, we're talking about like a chart where you put in the income, perhaps the number of years of marriage, and then come out with a number of what the spousal maintenance should be. We have no strict guidelines in Arizona for spousal maintenance. It's a very subjective determination that the judges each consider the factors under the law. And it's more than just the income and the financial need. The court looks to the property that's been apportioned to a spouse. For example, if a spouse is awarded property in the divorce that's far more than is sufficient to meet their needs, like rental property that brings in a rental income of an amount of money each month, more than what they need to meet their expenses, then by virtue of the property that's been awarded to the spouse, they may not qualify for spousal maintenance.
Okay.
And there are other factors that the court considers.
No rules of thumb? I mean, I've heard, for instance, over the years, people say, well, I guess after more on the question of duration of alimony, there'll be rules of thumb. So many years of alimony for so many years of marriage, for instance. I know the amount's one factor.
I really don't use rules of thumb because each situation is unique, and I don't think you can assume that a judge is going to follow any particular assumption that if it's 2 years of marriage, then it's going to be 2 years of spousal maintenance. Each situation is unique, but in general, shorter marriages, if they do qualify for spousal maintenance, are likely to result in a shorter duration of spousal maintenance, and a longer marriage, if it qualifies for spousal maintenance, tends to result in a longer period of spousal maintenance, or perhaps an indefinite duration of spousal maintenance, which is a length of time that we don't know when we set the order.
Is there a minimum? I mean, as you raised the question there, it sort of fascinated me. Is there a minimum length of time you have to be married before you're eligible for alimony in Arizona?
Technically, no. There are situations where even in short marriages, a party perhaps gives up an excellent job to move from some other place to Arizona and really limits their ability to earn income in exchange for the benefits of the marriage and because they want to marry. And they realize after a relatively short period of time that the marriage isn't going to work out, divorce takes place, and in that case it's possible that spousal maintenance could be ordered even for a very short duration of marriage. But unless there's a good reason, it would be a hard case to make to demand spousal maintenance after a 6-month marriage or even a year-long marriage, unless there was facts to support it.
How about modification of alimony? Can it be modified once it's ordered?
It gets a little complicated, but definitely understandable. In Arizona, there's 2 ways that spousal maintenance can be ordered. It can be modifiable and non-modifiable. If the parties have to go to trial in order to resolve their spousal maintenance issue, and the court issues an amount of spousal maintenance, that order is always going to be modifiable. And that means that if one or the other parties wishes to come back to court because of a change of circumstances that's substantial and continuing, the party can petition the court to consider modifying that order, increasing it or decreasing it. But there's also such thing in Arizona as non-modifiable spousal maintenance. This is a type of spousal maintenance that's enabled by statute in Arizona that allows a specific amount of maintenance for a specific duration of time, and then the maintenance terminates forever. The non-modifiable spousal maintenance that I'm describing can only be accomplished through a settlement, not by a court trial. And so often we propose in the settlement process the benefit of the non-modifiable spousal maintenance a possibility.
I understand you correctly, the court cannot order non-modifiable?
Correct. Any spousal maintenance order issued by a court, even if the court orders it for a specific duration, can be modified if there's a substantial and continuing change of circumstance. The court doesn't have to modify it, but if the court orders spousal maintenance for a year and in 9 months some horrible thing happens such that the recipient spouse needs it for longer than a year, they're allowed to go into court and try to explain to the judge why it needs to go beyond a year. And similarly, the other party, if they lose their job and can't pay for as long as a year, they can come back to court and try to modify that. But if it's a non-modifiable spousal maintenance order accomplished by virtue of a settlement agreement, then courts are limited and cannot modify those orders.
Before I forget, I knew I was going to do this, let's put your information back up on the screen. So if you want to get in touch with Attorney Keith Singer, there's his telephone number and his website, and you can do that. As I said, we'll hopefully do it one more time before we end. Okay, Alimony. So what happens is if there's some changes in circumstances, a person loses his job and is modifiable, they can come back in. How about unpredictable things that happen? For instance, a bonus. How do you deal with a bonus? I mean, a man gets half his salary as bonus, and so he may, and certainly in his current economic climate, we don't know. Sometimes he gets a bonus, sometimes he doesn't. How do you handle bonuses?
The term that we use is substantial and continuing change of circumstance. Substantial meaning that it's not a 5-cent raise or something de minimis as compared to what the prior income was, but something that is substantial, something big enough to make a difference. And then it's got to be continuing, meaning that it's ongoing, not just some isolated event. So a bonus would be evaluated by the court in the context of, well...
Does that have to go back to court every time they do this, or is it possible to build that into the order of the court, which says you get a percentage of the bonus or something like that as alimony?
It is possible. By settlement, the parties can make provisions for spousal maintenance that can include any number of eventualities that could take place that they can anticipate, but that the court might not. Courts are a little bit more reluctant to try to predict the future, and although a court could conceivably say that should there be a bonus next year, wife or husband is entitled to a certain percentage of it, that's not a common provision that I see, though it is possible. Otherwise, it's the obligation of one or the other of the parties to come back to court and ask the judge for a modification based on that change of circumstance.
My experience with the couples, they don't want to go back. Once they go to court, they don't want to go back. They see it as a cost, they see it as a hassle, so that they want to do that. But
one of the benefits of settlement of family law cases, I mean, I am generally a trial lawyer, but like you, I believe in settling cases whenever possible, and there's benefits to settlement, such as creating language that is really unique and customized to the parties that you're describing right now.
We talk a little bit about child support. What's the relationship between child support and alimony?
They do play into each other. Child support reduces the amount of income that someone has available to pay spousal maintenance, and it also is added to the income of the party who is receiving spousal maintenance. So the courts will consider that factor in determining the issue and in the numbers.
How do you see it? One of the things I see sometimes comes up, and I'm not sure how you handle this one, is you have a young couple, have a kid, they get divorced after 2 or 3 years, the child's 2 or 3 years old, and the alimony in that situation wouldn't necessarily be all that long because it's a short marriage. We talked about that one, but clearly the person's going to have a hit if the alimony is for 2 years just getting child support. What happens in those kind of cases where there really is not going to be a long-term, could be 16 years or so. Let's say it was 2 years of alimony, there'd only be 16 years without alimony and the wife might not have enough money.
The best answer I can give is that the unique circumstances of this situation would be, applied to come up with a spousal maintenance outcome that would fit.
It might be longer, so it might be longer even if it was a short marriage.
It could be, and child support in Arizona does follow the guidelines, so it's quite rigid. And then we create a spousal maintenance outcome that sort of fits from that initial child support calculation. A
few more questions I want to make sure we get to. What about the tax implications? That's something I think is widely misunderstood by parties.
Unlike child support, which is tax neutral, spousal maintenance does have tax implications, and it's really important to consider them. The spousal maintenance is includable in the income of the recipient spouse. The person that is receiving the spousal maintenance has to pay taxes on the spousal maintenance they receive, just like any income and any other income. And the person who is paying spousal maintenance gets to deduct the amount of spousal maintenance dollar for dollar from their income. payment of spousal maintenance and the tax benefit from that is very similar to the tax benefit of a mortgage. The amount that's paid on interest for a mortgage is deductible from income. Similarly, the amount that's paid for spousal maintenance, dollar for dollar, is deductible from income. But what's really important to consider, especially for the recipient spouse, the one that's receiving the spousal maintenance, most people receive their pay by a paycheck, and the taxes are taken out as they receive their paychecks. So they don't have to pay a big tax bill at the end of the year, and often more is taken out than what their actual taxes are, so they receive some refund. Well, in spousal maintenance, the recipient spouse has no withholdings from the check each month. It's just, if it's $1,000 a month or $500 a month, it's going to come in that monthly amount. So they're not going to be paying taxes on it as they go. And what I tell my clients who are receiving spousal maintenance is that they really have to hold a little bit aside each month, because at the end of the year, they'll be taxed on the total amount of spousal maintenance they received without any consideration for any withholdings, because they wouldn't have taken place.
Do they have to do quarterly?
Not to my knowledge. The CPAs will know this more specifically, but most of my clients who receive spousal maintenance don't pay quarterlies as a practical matter, and they wind up getting hit at the end of the year with a big tax bill on that spousal maintenance if they haven't set something aside. So taking 15, 20, 25% of each payment, or one out of your several payments, and putting it in the bank is really necessary to avoid that unfortunate tax hit at the end of the year. What it might also do is eat up the refund that would otherwise be received, and people count on that.
Yeah, I just find that a lot of times people will take what their salary is and then sort of deduct the alimony from it without looking at what the tax benefit is, and so they think that it's sometimes it could be substantial. And I think, I guess, in some cases, when you have a situation where you have a husband at a high tax rate and a wife at a low tax rate, you essentially have the wife as a tax shelter.
Yes, and we utilize this as a settlement strategy, because the benefit for the person who's paying spousal maintenance of the tax deduction that they're getting from paying the spousal maintenance may make it a lot easier for them to write that check every month, knowing that such a substantial portion, especially if they're high earners, they're going to get back in a tax benefit. So we consider that in the settlement process.
Is spousal maintenance just for the rich, or is it across the board?
It's across the board, and I think it's the scale of spousal maintenance that changes for the rich. If the payor spouse, the one paying spousal maintenance, is making $100,000 a year or $200,000 a year, then they're often going to have a lot more excess available after payment of their expenses to pay spousal maintenance. But for someone who is making much less, $30,000, $40,000, $50,000 a year, most of that is going to go to pay their necessary expenses. So what's left over for spousal maintenance is going to be much smaller. What this means is that for people with less income, the amount of spousal maintenance will be less generally than for people who make large incomes. But the criteria for receiving spousal maintenance is the same for rich and for poor. So even if client comes from a modest income situation, they may still be able to receive spousal maintenance, and for as long as someone who came from a rich family, but the monthly amount will be less. But from their financial life, that extra $50, $100, $200 a month may make all the difference in the world to help them make ends meet.
Let me show, before we forget again, how you can get in touch with Attorney Keith Singer. There's his information, a telephone number and website. Keith, are there events which are automatically terminate alimony?
Remarriage of the recipient
is
spouse is an automatic termination of spousal
maintenance. If somebody wanted to keep it even if they remarried, is it possible?
It's a really interesting question, because I have cases where this is considered, and the answer is I'm not entirely sure. I don't want to give a wrong answer.
Okay.
It's generally a pretty hard and fast rule that spousal maintenance terminates upon remarriage.
They would want to do that, but
well, people strike deals to settle spousal maintenance, and they have the freedom to construct those deals in ways that fit them, and I support that. My belief is that it is possible to create a spousal maintenance settlement that would, as part of the provisions, allow someone to receive spousal maintenance even after they were remarried.
What other terminating events would terminate?
Death of the often either spouse will terminate spousal maintenance. Certainly death of the recipient spouse, meaning there's no more need for spousal maintenance for them, will generally terminate spousal maintenance. And death of the payor spouse will often terminate. Those can also be modified in the settlement process if the parties indicate as part of their written settlement that they wish to change those provisions.
Let's go into one of the other events which I always find interesting to deal with is cohabitation.
Well, technically, cohabitation.
What is for those of us aren't.
In my view, cohabitation, what you're referring to, is one or the other of the spouses gets a new relationship and starts residing with someone else who is not the person they're married with or the person that they've recently divorced from. And in Arizona, to my knowledge, cohabitation in and of itself doesn't affect spousal maintenance, although it could have some indirect effects. For example, when you cohabitate with someone, often you're sharing expenses with them. So what was 100% of the expense might now be just 50%. Let's say they're sharing the cost of the rent or the mortgage. So cohabitation could affect financial need if someone is receiving some supplement from their partner, and that may give rise to a modification of spousal maintenance because they don't need the same money that they were in need of at the time of the divorce. But just cohabitating in and of itself, to my knowledge, doesn't affect the issue.
Okay. I mean, it just seems to me sometimes people say, well, I won't get married, I'll just live with a person, so I keep getting my alimony.
Courts can decide.
My kid said, why is my uncle not married to the new lady and she didn't want to lose her alimony.
Well, I think many people in that situation do make the decision not to remarry, to continue to receive the spousal maintenance. And I think courts can consider, if the issue comes before the court, the fact that there really is a sharing of expenses, and even though there isn't a remarriage such that there would be an automatic termination of the spousal maintenance, there is a sharing of expenses such that the financial need is reduced. But I think you're right. People do hold off for that reason.
If you can say in 10 words or less, where can people get more information about spousal maintenance? Because we have about a minute left.
Well, the Internet has a lot, and there is a self-help center at the Pima County Superior Court on the second floor that many people utilize. And there's a lot of excellent family law attorneys to utilize as well.
We just really scratched the surface on the topic. We didn't get into enforcement and a lot of other issues on it. So it's a complicated thing, but we're doing it. But I want to thank Keith for being with us. It's fascinating. Every time I have a guest on, I learn something new.
Pleasure.
On that one. And if you want to contact us or check our guest who gave us the information on that one. And it's been a pleasure talking to you. And it's